We plan out our trial stories well in advance, and they're a work in progress. But just because it's like a hypothesis, we have this is what our hypothetical trial story was going to be, and then we have to test that about what did we learn in discovery, and then we're doing focus groups. Do people buy our theory?
Yeah.
And I'll give you an example. You and I are getting ready for a trial later in February, and we worked really hard with a consultant before we did any discovery, and we came up with a theory of the case, and we had all these great graphics, and we had a plan. And now that we've developed all the evidence, we do not think that is the most compelling story and the best way to win. So we have come up with what we think is a better story, but it means we're not going to use a bunch of the posters. We have the opening plan we had from a year ago, and that's when we actually did start thinking about what the opening would be over a year before we did our first depo.
Right.
But it's not the same opening that we're going to do after doing all the discovery.
Yeah. Yeah, I think that's right. And so it depends on how much time you can really focus on. I mean, I don't want to be unrealistic. We can say what everybody's goals are, but realistically, for most of the cases that everybody tries, most people don't have a 2 or 3 case docket.
Right.
And we don't. And unless you have a 2 or 3 case docket for every single case of yours, you can't start working on the opening the day you get the case. Well, we did that on that case. It's because it's a big case and it's an important case. Not that they're not all important, but it's one of the biggest cases at our firm. It got a little bit more attention in terms of doing the opening right away and all that kind of stuff. So.
But even then, it's not going to be anything like the opening we're going to give in 3 weeks.
Right. And it's changed so much since the very beginning. And I think that that's also the danger of doing something very early, is that it is very hard to not stay committed to what you decided the case was about originally. I mean, you put all this work into a certain theory or a certain way of thinking about the case. It is hard to just give it up when you've thought about the case that way for so long. I mean, we spent the entire day yesterday going through how the case has changed from what we thought. That particular case we're trying in about a month, how it's changed since what we initially thought about it. And, it took a lot of back and forth and us going through the evidence that we actually collected and going through what we thought originally. But we decided the best for the case was to change course.
Well, even this case that we're hopefully going to try between today when we're recording it and February 1st when this episode comes out, we thought we had a really powerful piece of evidence because it's a workplace injury, someone was killed, and afterwards someone came up to the police and said, hey, I worked for another city, this same company did something similar and gave a statement and had pictures, and we took his deposition, and that was going to be a huge part of our case. Yeah. But when we really started looking at it closely and we thought, well, this is going to cause some confusion. It is kind of different. We're not sure he was 100% right on his allegations. Is a jury going to hold us to a higher standard? Like now we have to prove they were bad both times, and we decided that we have a super strong, simple case. And so a lot of the other things that the defendant did wrong, like in the past, and even things they did wrong that day that weren't causal or weren't necessary to prove, we decided to simplify the case and change the opening.
And a big part of doing that was looking at what our jury instruction was, which sounds elementary because, well, the jury instruction in this case changed substantially. But originally it was a basic negligence instruction. But looking through it and thinking, what is it that I need to prove to establish causation? What are the only things that I need to prove? And then looking at all of our other evidence and saying, well, is there another reason to put this in? And most of the time the answer is no, there's not a compelling reason to put something in that's useless.
It causes confusion and makes it complex.
Right. And so really storyboarding it out and mapping it out and writing your order of proof and saying, here are the things I need to prove, here are the exhibits, here are the witnesses, here are the things that someone needs to say to prove those things, really simplifies the case. And for a wrongful death case that has it's a workplace injury, so there's some complex regulations involved, our goal is to try it in 3 days. I mean, because we've simplified it so much, but that doesn't happen overnight.
Yeah, and I think one of the things is that, we spent a lot of time and work, you especially, making all these graphics, and we printed up like 80-something huge boards to use for trial. And then I went up and worked with Sari de la Motte on my opening. And we were talking a little bit about simplifying before, but she's like, if you say that this is a simple case, but then you use 60 boards during your opening, your actions are saying it's a complicated case, and your actions and your words are not congruent. And so you need to do that. And so we really we found our on-off switch. It's like if they did X, which was required by law, he's alive. Because they didn't do X and they broke the law, he's dead. And, everything else is just kind of icing on the cake, but we don't need to get into every other little thing they did wrong because it just confuses them. And it also,
Right.
in fairness, did not cause the death. The other things they did wrong were not causal, they were just other violations.